Hi, and welcome to the podcast of Learn Law for All. Today we are here with Randi Burggraff and Michael Dinn. And a little bit about Randi. Since earning her law degree, Randi has dedicated her career to helping parents secure their rights and the rights of their children in even the most volatile situations. And she's able to do that because she has a great background for this. She has a background in psychology as well as family and children's services. And so she really puts that to work in her family law practice. Michael Dinn has been serving the Scottsdale, Arizona community through appeals and family divorce and family law since 2017. And he's dedicated to securing justice and fairness for all of his clients, and he enjoys seeing the law upheld and developed for the good of the community. And he really focuses a lot on appeals, so that's really great. I'm really thankful to have both of you here, so welcome.
Thank you.
Thank you.
So again, as you all probably know, this my disclaimer, the podcast is for educational purposes only and in no way should be considered legal advice. Watching this video does not create an attorney-client relationship. And Randi, Mike, and myself were only licensed in Arizona. And so even though these concepts are really for Arizona, I think the concepts can be kind of understood nationwide with the changes that we're going to talk about, modifications. But of course, always check the laws in your jurisdiction before relying on this, because laws in each jurisdiction change. And by the way, laws in, every one jurisdiction can change in a day, right? So thank you both for being here.
Absolutely. Thank you for having us.
Right. So we're talking about modification, and we just did a CLE on that will be that's also available through our Learn Law for All website. But talking about it, modifications can be difficult, right?
Yes.
And so when somebody comes to your office and asks you to modify parenting time, what does a conversation look like with them? What do you kind of ask them, and what do you inform them?
Absolutely. Great question. So if I'm dealing with a situation where I have a modification of parenting time, or maybe even legal decision making is a part of that or separate from that, the first sort of conversation I'm having is I want to know what the prior orders say. And when they were entered, right? So step one is figuring out whether or not I've met, or rather the person who wants to file, if they've met the time requirement. By statute, it is 1 year, but there are exceptions to that when there are situations where there's endangerment, of the child, or if there is a joint decision-making award and after 6 months, someone's, abusing that. And we've talked about that, during our CLE segment. But the other part of it is why are we modifying? What is the change in circumstances? If I have a parenting plan in front of me that says X and my client wants to do Y, what is the reasons as to why they want to do that? And really having that detailed conversation with the client about whether or not they're meeting that burden that the court is going to require, that is going to be their responsibility to show that there's been this change. And that really can go two different ways. Do I have a parent that has, an equal parenting time plan, and all they want to change it is from one equal plan to another equal plan because there's problems with the original plan that they have? Do I have situations where a parent has, limited parenting time, whether it's unsupervised, non-overnight, or supervised time, or every other weekend, and they're looking to increase that? And so I'm really having a detailed conversation with my client about what things have happened, what has happened in the year 1, 2, 3, 4 years that warrant the ability to modify. For example, let's say you have this unsupervised parenting time, and there was a very like the supervised parenting time or unsupervised non-overnight, and there was a very specific reason as to why. Have those things changed? Have you done, let's say it was, a substance abuse issue. Have you been sober for a period of time? Have you taken classes, gone to therapy? Is the other parent allowing you, unsupervised or overnight contact? Are those the circumstances that have changed? Do you have an equal plan that is like a 2-2-3 plan? And that was, agreed upon when kids were 3 and 5, but now they're teenagers and, it's too hard because they're in sports and we've got the equipment that's moving. There's a lot of conflict as a result of the plan. Kids are forgetting where they're supposed to be going. There's too much interaction and exchange, and maybe a different plan would be appropriate. And so I'm really diving into my client about like what they're looking to modify and having that conversation to decide, whether or not it's worth incurring the costs, to look for that modification.
All right, great, thank you. And now kind of the same question about child support. How do you address child support when somebody comes in and says, hey, I want to modify my child support?
I feel like that one's easier. And I say easier because I think child support modifications are more frequent and they're a little bit easier to do. But to me, it's more of like a monetary reason. Why are you looking to do it? Is somebody's income increasing, decreasing? Are we removing a child from the worksheet because they've emancipated? And then I'm running child support worksheets for them during that consultation while we're having the conversation, because I want the client to see what the increase or decrease could be, right? So if I have a $500 child support award, let's say that my client is capable of meeting the burden required by the court in terms of the continuing change of circumstances that's happening. And they're looking to increase the amount or they're looking to decrease it. Maybe it's just $100 either way. I then want to have the conversation to say, okay, look, you have a case, you have an ability to modify, you're meeting that change, but is it financially worth it to you? If you're looking to only decrease your obligation by $100, but I charge, this as my regular rate, is it worth you incurring the costs in order to do that? And then it goes the reverse way. If you're looking to, increase it, but it is only by $100, $200, $300, is that worth it from a financial standpoint? Because while the modification of child support is, I think, quite a bit easier than that of parenting time or decision making, to me, the cost benefit analysis is quite a bit different because you are really just talking about dollars at that point.
And so, Michael, question for you. Is there any advice that you can give someone for making a pleading or creating their pleading when asking for the modification that you would like, in the event of an appeal, possibly?
Absolutely. And I think that this goes with what Randi was talking about as far as building up the case, if you will, through the consultation and meetings with your client, is just to be specific as possible. All of these pleadings that we're talking about here today, modification of parenting time, child support, even spousal maintenance, they're going to require some detailed facts to pass muster beyond the court's analysis of, is there a change in circumstances happening here that warrants a modification of some previous order? And that's the question. So to be specific as possible, demonstrate what changes happened. Why should the order be modified? How is this affecting, we're talking about parenting time, how is the change affecting the child? How is the orders no longer effective or logistically impossible? Maybe somebody's moved. There's so many different changes that can happen in a family law context. It's just really important to be specific and as detailed as possible when you're writing that initial pleading, so the court can understand the case, and also from a practical standpoint, so you can survive a motion to dismiss, because those are really common in this realm of practice. There's a lot of times when one will submit a petition to modify, whether it's parenting time or spousal maintenance, it's oftentimes met with a motion to dismiss for failure to state a claim relating to the change in circumstances.
Great, thank you for that. All right, so here's the one that I wanted to talk to you about. Is there ever a reason, and I know Arizona law, if the court's making the order, spousal maintenance is modifiable, but is there ever a way that spousal maintenance is non-modifiable?
Yes, there is. And the way is, it's technically through 25317G, and that's Arizona revised statutes. It states, along with ARS 20, I believe it's 25327, that if parties agree that an award of maintenance shall be non-modifiable, then the court at that point loses jurisdiction to modify such an award.
Okay, so and I guess there's probably good reasons and bad reasons for both, right? I mean, I think entering into a non-modifiable spousal maintenance claim can be dangerous for one of the parties, for sure, right? Actually, maybe both of the parties.
Right. Because you can't, I mean, if at mediation, the two parties agree for it to be a non-modifiable award, the party receiving the spousal maintenance is not eligible to increase, that award, whether by duration or dollar amount, and the party paying it is all, saying not eligible to, request the court to modify, to decrease that obligation, whether by duration or dollar amount, you are stuck with the order, regardless of what, circumstances happen where you may have been successful on a modification had it been a modifiable order. So absolutely, it's important to take into consideration the pros and cons of modification of that type of agreement. And maybe even considering if there are concerns that modification may be appropriate, considering including that as part of your agreement, if those circumstances may be applicable, like health issues, things of that nature.
One other point on that is that if you're the one that's seeking, or if your client is the one that's seeking the non-modifiable award and everybody agrees to it and you're drafting the agreement, be clear about what that agreement is. It's non-modifiable. Don't leave any ambiguity in there, such as language like until further order of the court, because when you start putting extra things in like that, it leaves open the interpretation that the parties intended to
do something different.
That the court continue to exercise jurisdiction over the matter.
Okay, well, thank you both very much. We just had done a CLE on this, on modifications, on how to file the petitions. So if you're interested in that, come to learnlawforall.com. And thank you both very much. I appreciate you being here.
Thank you for having us.